Right, thank you for listening back. So we're back to Article 5, duty of the court in connection with acts which should be repressed, but which are not covered by the law, and in cases of excessive penalties. Whenever the court has knowledge of any act which it may deem proper to repress, and which is not punishable by law, it shall render the proper decision, and shall report to the chief executive through the Department of Justice the reason which induced the court to believe that the said act should be made subject subject of penal legislation. In the same way, the court shall submit to the chief executive through the Department of Justice such statement as may be deemed proper without suspending the execution of the sentence when a strict enforcement of the provision of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. Now for Article 5, it talks about the duties of the court in relation to acts that needs to be repressed but is not covered and is not punishable by law, and for acts that are for executions that are beyond, or the enforcement is beyond the believed to be beyond what is reasonable for the acts done. Now let's get into each paragraph. So there's paragraph 1, which will repress criminal acts, and paragraph 2, which which would try to repress, or which would look into cases that are excessive in penalties. Now in paragraph 1, the requisites, or basically what is said on paragraph 1, are that the acts committed by the accused appears not punishable by any law. So there are no law that punishes that act. So nullum crimen, nulla fine legit. So there is no crime when there is no law punishing it. Number 2, the court deems it proper to repress such act. Number 3, the court must render the proper decision by diminishing the case and acquitting the accused, since there is no crime done with the act. Number 4, make a report to the chief executive through the Secretary of Justice reason which induced the court to believe that the said act should be made subject to penal legislation. So once again, paragraph 1 talks or establishes acts which should be repressed but is not covered by the law. Now for paragraph 2, it's excessive penalties. Excessive penalties for the act done. Now for paragraph 2, we establish it's basically established on these grounds. Number 1, after the trial finds the accused guilty. Number 2, the penalty provided by law and which the court imposes for the crime committed appears to be clearly excessive. So it's clearly excessive on the penalty of the accused. So what does excessive mean? So number 1, the accused acted with lesser degree of malice. So there's lesser degree of malice on the part of the actor. Number 2, there is no injury or the injury caused is of lesser gravity. So the injury is lesser than what is expected of it. And number also for on the next part, as we move on to paragraph 2, the court should not suspend the execution of the sentence, and the judge, number 4, the judge should submit a statement to the chief executive through the Secretary of Justice the statement that which is deemed necessary to state that the acts done or the imposition of the decision was beyond reasonable. Alright, so that was Article 5. Now let's move on to Article 6.